Hi, Sumeet. Welcome to my podcast. Thank you for taking out time. How are you doing today?
Good, good, Harsh. How are you? Thank you for having us.
My pleasure, sir. I appreciate it. I just quickly want you to introduce yourself to the audience so that they know more about you.
Yes, of course. I'm a real estate lawyer with Legal Lab. Our main practice is real estate and corporate law. We do specialize in pre-construction. So we help developers on the pre-construction side as well as purchasers on the pre-construction side.
Nice. How's the market going on these days for you guys?
You know what? The market is slowly picking up now. We've seen a lot of refinances in the last 2 years, everybody trying to stay afloat and keeping up with the increased payments. But now, in the last, I would say about 3 months, we're starting to see a little bit of activity, and it could be the cause of interest rates that are falling and the new regulations of mortgages and for first-time home buyers. But
Yeah.
activity is slowly picking up. Of course, at this time of the year, it is near about the holiday season, so it's starting to kind of slow down now. But I would say we're headed for a good year ahead.
Beautiful. Sumit, so I do work with a lot of like investors and first-time home buyers, and they have like a lot of questions. I've shortlisted some of the top questions which I wanted to discuss with a real estate lawyer and expert like you, so that we can go through and answer them, right?
Of
So
course.
the one major questions that we have is that these first-time home buyers always ask is, what are the hidden costs of buying a house?
Of course, and that's a great question because a lot of clients that do come to us, especially first-time home buyers, they're shocked with all these added fees on closing day. And sometimes it could become burdensome on the day of closing when you're trying to come up with extra funds because first-time home buyers, as you know, they've already gathered every single penny that they have. But
Right.
when it comes to hidden costs, I think it's important. The first item I want to mention is land transfer tax, and this is a tax that not a lot of clients are aware of. And so it's always a good idea to maybe just Google land transfer tax calculator and just get a little sense of what that could cost on the day of closing. And a lot of clients don't know that in Toronto, it's double the tax. So if your property is located in Toronto, not only do you have to pay the municipal, but you have to pay the federal as well. So it becomes double. And a lot of people are shocked to know that on closing day. When it comes
Wow.
to legal fees, of course, there's going to be your closing fees with the lawyer. However, when you get quoted by your lawyer, you want to ensure that you know what the disbursements look like. The hidden disbursement that a lot of purchasers don't know about is title insurance, and title insurance is you can't get around title insurance because your lender requires it, and it's important for you to kind of get to protect your title. But title insurance is also increasing, and I've seen title insurance go anywhere from 500 and all the way to $2,000, really depending on how much your mortgage is and what the risk level is. Another few items to keep in mind is, especially for first-time home buyers, if you're not buying pre-construction, you want to budget a couple of $100s for a home inspection. That's really important. And that, of course, happens at the time when you're making an offer. It could be conditional to your offer, but it could cost anywhere from $300 to $500 depending on the size of the home. It's really important to inspect the roof and inspect the furnace, and if there's a oil tank, you want to inspect the oil tank, septic tank, cistern tank. Um, and of course there's other costs as well, which is related to your mortgage. For example, a lot of individuals, if and this doesn't apply to, of course, first-time home buyers, but for even new buyers that have had their first home, they don't know the implications of penalty when it comes to exiting a mortgage. So the first thing you want to do is call your bank, find out if you can even exit, and if you exit, what does the cost look like? What's the penalty that's involved? And if you don't have a mortgage, then when you're speaking to your broker, that's getting you a new mortgage, you want them to kind of clarify what the lender fee and the broker fee could be, because sometimes on the day of closing, when we get a letter of direction from the client's broker, sometimes they're not even aware that there's 1% or 2% significant. It could become a significant amount, and they're not aware that that amount has to be paid on closing.
Wow, so many costs, right?
So many costs.
Since you mentioned the word pre-construction, what I want you to tell, what is the importance of reviewing these pre-construction contracts?
Pre-construction, it's really important to get a legal review completed by a lawyer, especially when it comes to condos. Now, the law gives you 10 cooling day period, and they're giving that for a reason, because it's a long document. Sometimes at the sales office, you're forced to firm up, especially when it comes to freehold. But let's talk about for condos. Let's so on the condo side, and this applies on the freehold side as well. You want to make sure that HST is included in the purchase price. And a lot of times, especially in the GTA, it is included. But if you're an investor, you need to make sure that you may have to pay the $24,000, which is the rental rebate that you have to apply for through the CRA, but it cannot be credited by the builder. A lot of builders do not credit that because there's certain requirements that you have to fulfill to be eligible for that rebate. So that's, I think, is always a shocker for my investor clients on the day of closing when they have to come up with an additional $24,000. You want to make sure deposits are insured. You want to look out for any occupancy fee. Is it going straight to registration? Or if it's not going to registration, and you're occupying it before registration, of course, there's an occupancy fee. You want to know how that's being calculated. Common expenses. If you're buying a condo, if your unit's part of a condo corp, you want to know what the maintenance fee is. How is the maintenance fee calculated? Termination rights, and this is actually a big one as well. Termination rights by the builder. You want to know when the builder has the right to cancel the agreement that's in place. Now, some agreements could even have expiration of this clause that's 2 years after you sign. And what that means is if they don't meet their preconditions, whether it's for sales or whether it's for construction financing, they can easily cancel the agreement and just give your deposit back. So you have to be mindful of that. You need to watch out for these preconditions. The biggest one is adjustments that could be on top of the purchase price. This includes education levies. This includes development levies, parkland levies. So you do want to ensure that majority of these levies are capped. And of course, the lawyer would help you identify the items. And nowadays, you can find it in the Tyrion addendum. There's a list of additional costs that could apply to your purchase on closing. You want to be mindful of that. Another big one is prohibitions or conditions when it affects the rights of assigning the unit or leasing during occupancy. That's a big one for investors. Selling or marketing any assignment. A lot of agreements do not allow this, and there's been cases even with my own clients where their agent has gone ahead and put the listing on, whether it's Facebook or MLS or even Kijiji, and that will put you into breach of the contract because there are clauses that do not allow this.
Right. And that's really a big one.
Mm-hmm. Yes, definitely. That's definitely a big one.
That's why I always recommend to all my clients and investors that always get these APS reviewed by a pre-construction lawyer expert, so that there's no surprises down the line.
Of course.
And Sumit, like when buying freehold properties, what are the most important things to consider?
When it comes to freehold property, whether you're an investor or whether you're an owner occupant, you want to make sure that there's no tenants in the property. And I know that's a growing problem nowadays, where you buy a unit, you think you're going to be living there, but now there's a tenant that said they would leave, but they haven't left yet.
Wow.
Once you change title, now that becomes your problem. So you have to go to the tribunal. You have to wait maybe 8 months, 9 months to get the tenant out. And that's I'm seeing that being a growing issue nowadays. So you want to make sure that you take possession, vacant possession.
Okay. And
When
so
there's
if I'm buying a property and my closing date is, let's say, 1st of January, and they said that the tenant would leave, we have signed all the required forms and all and stuff like that. And what if they don't leave? So do you recommend that we should do an inspection a day or two before closing date, so that there are any surprises, we can always go back and forth to the lawyers?
Yes, of course. It's always good to do an inspection right before the closing date. Now, you always should have a condition in there. If you know there's a tenant in the property, you should always have a condition in there, in your offer, to say that you're taking vacant possession. If the seller cannot provide vacant possession, you simply don't close. And whoever your lawyer is, you advise them that we're not closing if there's no vacant possession. And I think that's the most important thing when it comes to tenants in the property.
Right. So, but whatever agreements that we make for a freehold property, the vacant possession clause is already printed there, right?
Correct.
So do you recommend we should add something more in Schedule A of that agreement?
Yes, I would recommend that. I would elaborate on that condition so that it's clear, so that there's a clause that suggests that there will be a mutual release, or if there's not going to be a mutual release, is your client, who's the buyer that's put up the deposit for 3 months, is he going to be claiming damages or interest on that deposit? So it's always good to have it clear in the schedule, and both parties are aware that if there's vacant possessions not provided, these are the terms of the release.
Okay, that's a good one to know. But if we are not closing on the property on the day of closing because the property is not vacant, as a buyer, will we be in breach of contract, and can we be sued?
You will not be in breach of contract, because we have a condition on the agreement of purchase and sale that suggests that we are only taking possession if the unit is vacant. If the unit is not vacant, then, and that's why it's important to put in the schedule the terms of when this issue does come up, what are the terms? And it's always best to kind of put it in writing right in the beginning on the offer day.
Got it. That's really important, right?
Very important. A lot of people honestly miss that clause in the beginning, because sometimes the seller or the vendor is certain that they can get the tenant out, but nowadays you just can't trust the tenants, that if they don't find another place, they're just not leaving until they find another unit.
Right. Well, that makes sense. And also, I wanted to know that when investors or first-time home buyers, they are buying these pre-construction properties, and these days we are seeing a lot of projects getting canceled and stuff like that happening. So I wanted to know, when they are buying these pre-construction properties, the deposit that they put in a lawyer's trust account, are those deposits safe and insured?
So there's two sets to that question. Now there's if we look on the pre-construction condo side, that works a little bit different. So on the condo side, the builders are required by the Condominium Act to place all deposits in trust, in the lawyer's trust account, and they cannot be released until, of course, closing day. On top of that, they have Terion insurance. So Terion covers about $20,000 on a condo unit, but of course nowadays with the deposits and the increased prices, $20,000 doesn't really do justice. So you want to make sure that the deposit is actually being held in the lawyer's trust account. And on the pre-construction side, it's fully protected. So you're secure on that side, on the pre-construction condo side. freehold homes work a little bit different. So
Right.
with freehold homes, there could be terms in the agreement of purchase and sale that allow the vendor to have the funds from trust released for their use during construction. So you
Okay.
have to be, when you're reviewing the agreement of purchase and sale, this is a clause that you really have to watch out for. Because deposit, so on a Tarion, and you need to make sure that your freehold home is actually Tarion insured and it has Tarion. Sometimes when you go to a smaller builder, they might not be Tarion approved. They might just be a custom home builder. So you do want to make sure that there's a Tarion addendum to kind of verify it. You can always go to the Tarion directory to confirm that the actual project that you purchased is Tarion warranted. Deposits that are, let's say, $600,000 or less of purchase price, your deposit will be protected at a maximum of $60,000. If your purchase price is over $600,000, then there's a maximum protection of $100,000. But again, you have to be really mindful when it comes to freehold homes. The vendor could take a release from their lawyers, depending on the clauses that are in the agreement of purchase and sale, just to use those funds for construction.
Right. So for example, if we are dealing, let's say, first in pre-construction condos, and let's say the purchase price is $2 million, and they are putting 10% down, which is $200,000, right? So by tariff, you're saying that only 100,000 would be protected?
Only protected through Tarion, so only if it has Tarion.
Okay, and there is something also we have read in these contracts is excessive condominium insurance that sometimes these developers take.
Of course. So when you see certain clauses, especially where it says the vendor is allowed to take a release from the trust, in that case, you do want to request proof of excess insurance. These builders sometimes have additional insurance in place other than Tarion that do cover the full amount of your deposit.
Right. So in that case, if the builder has that insurance and the client's money that is in the trust account is fully safe and insured, right?
Correct. Then you're fully insured, you're fully safe. And like you said, if the builder goes belly up, then you know you have an insurance company that will cover your deposit.
Okay, and that provides a lot of safety too.
That provides a lot of safety. On the condo side, you're okay, because if the vendor goes into receivership or bankruptcy, your deposit's protected regardless, because it should remain in the lawyer's trust account. Of course, there's a process in place. You have to wait for the court order and get your deposit released. Yeah.
But at least your deposits are safe, so you will get it.
Deposits are safe.
It's just a matter of time. But whereas if you're buying a freehold property from a developer, then your deposits are also at risk.
Yes. And sometimes, and I'm sure you've seen it as well, sometimes these deposits, the vendors want the deposits to be deposited into their own accounts.
In their own personal use.
Yeah, that's when you need to make sure that there is insurance in place to protect those deposits.
Okay, that's good to know. And so when people are buying, let's say, an assignment sale, because we are seeing a lot of good deals on assignment these days, what are the most important things you would recommend to check when buying an assignment sale of a condo?
The very first item that I would look into is, and of course you would get your lawyer to look into it, you want to make sure that the assigner who's selling you this unit is not in breach of their existing agreement of purchase and sale with the vendor.
Right.
That's a major one. And they could be simply, like I said, they can be in breach of listing the unit for sale, and they breached the marketing and advertising condition of an assignment. Or there could be other reasons. They didn't make the payment of their deposit in time. So there can be several reasons why it won't be in good standing. So it's always good to make sure that what you're buying is actually in good standing and it hasn't been recovered by the vendor.
Right.
You want to always make sure that your offer to the assignment is conditional on vendor consent. And because this could take some time in some cases. Some vendors in their agreement of purchase and sale have a condition where it says we won't provide consent prior to 90 days of closing. So if closing's years out, then you're almost waiting on a conditional offer with a deposit that you've placed, and there's no guarantee that you will actually get that consent. You want
Right.
to make sure that the levies that we discussed up above, the adjustments on purchase price, are capped. And if they're capped, is that cap transferable over to the assignee? That's a major one as well, because a lot of what I've seen a lot of the times is they sell it as a cap, but then when they get vendor consent at the last hour, it clearly indicates in the assignment agreement by the vendor that that cap and those incentives are non-transferable. And this could be on any incentive. It could be a debt core credit. It could be anything. It could be a maintenance fee credit, whatever it is. You want to make sure that any of the credits that you do see, any incentive that you do see, is in fact transferable over to the assignee.
Right. And Sumit,
another another big item is debt core selection. Since you're buying assignment, that phase and debt core have, in most cases, is already selected. So you need to be mindful that you probably won't be able to make changes.
Right. But Sumit, what we have seen when we deal with our assignment purchase for our investors is that most of the time these development charges are not capped and these incentives are not transferred to the new assignee, right?
Correct.
So in that case, what should be the expectation of the assignee when it comes to the development charges? Can it be like $50,000, $100,000, or it can be as close to the reasonable amounts that they usually charge, $15,000, $20,000 for a condo in the GTA?
You know what? That's a hard question to answer, because the fees, I've seen it go to 10,000. I've also seen it go to 150,000. So it really depends on the actual vendor. And yeah, in clients were shocked that they had to pay. And even if it's a small purchase, I've seen a $500,000 purchase with a $30,000 development levy. And people weren't happy about that, because that was pretty much almost a portion of their deposit that they were putting down as a first-time home buyer. So it's really, really important to make sure that even if you're buying an assignment that's capped, you want to make sure that even if it's not transferable, and you might not know at that time when you're making that conditional offer if it's transferable or not, because you're waiting for the vendor's assignment agreement. Now, you want to protect yourself by putting a clause in your conditional offer to say capital levies at, let's assume it's $10,000. And if it goes above the $10,000, then the assigner is liable for it. So if the vendor, in that case, if the vendor does not transfer those incentives or the caps, then the assigner who you're buying the unit from is responsible for it. So you're essentially capping it with the assigner instead of the vendor.
Right, and that's how we are projecting our assignees, right? The new purchases.
Exactly. And there's also one, the biggest item, and that everybody should watch out for, is that a lot of these times when an assigner assigns a unit, there's an indemnification clause. In their conditional offer, usually the assigner's lawyer will put an indemnification clause to say that if you don't close, then you're responsible for any damages, because essentially the assigner is still liable if the assignee doesn't close. And if the assigner can't close and gets sued by the vendor, the assigner can kind of countersue the assignee for the damages. So you always have to be mindful that there's still, if you can't close, it's not just a wash and you walk away, you're still on the hook for damages.
Right. And speaking of damages, like, have you seen recently in this market, like developers suing their clients?
Yeah, it's happening. It's happening every week, and it's actually sad to see, because you're seeing appraisals that are coming 20-30% below what the purchase price suggested. And these clients simply can't afford to close because they have to fill the gap between the appraisal value and the purchase price. Yeah. So now what ends up happening is, especially if someone's purchased a primary residence and all they have is the money that's in their current primary residence, they just simply don't have access to more funds, so they can't close the property. And if they can't close the property, of course, they'll be getting sued by the vendor. Not only will you be getting sued, you lose your deposit, and if the vendor sells it for a reduced price, you're covering that. They're going to sue you for damages and, of course, legal costs. Yeah,
You have to be very
it's a growing. The last year, I would say, it's been very. Every week, it's been at least 1 out of 10 closings that are going to default.
Wow, that's a really high number, right?
It's a very high number. Yeah.
I hope now things settle down, and as we progress into the new year with low interest rates, I think market will picking up.
Yeah, markets have picked up, but institutions and lenders, they continue to stay conservative when it comes to appraisals. So appraised value comes at least 10, I'm seeing 10 to 15% lower than market value. And of course, this is just to protect themselves. But when you're 10 and 15% lower on the appraised value, it's a big gap to cover for the purchaser.
100%, yeah. And that's a big amount. Like for 600,000 condo, it's $60,000 to $70,000.
Of course.
Yeah, that's good. All right, Sumeet, I really appreciate for your time and thank you for doing this. And we'll be in touch.
Thank you, Harsh. Thank you for having me.